cancer. So I apologize.
I hadn't been aware of that. That's a new development since I last spoke to you.
As unfortunately in this, but you can hear me right.
All right. Well, you got 3 zoning tickets.
Yep.
251640N, zoning violation, City of Sturgis. 251650N, zoning violation, City of Sturgis. 25166, zoning violation, City of Sturgis. The offense date is listed here, isn't right. One is October 30th, I think it means 24. One is December 12th of 24, and one is October 30th of 24. The matters have all resulted in convictions, and Mr. Reed, the Sturgis City Attorney, is asking for a compliance order to get this into compliance or allow the city to do it. Mr. Reed, what's the circumstance here?
As of this morning, the violation still exists, and at this point, so at this point, we would ask the court enter a compliance order that if it's not remediated within 30 days, the city can go in, remove the tent structure, and tow the vehicles that are in violation.
Well, right now I don't have any evidence other than other than what you just told me.
Well, I just sent the photos from today, and he's been convicted of it, and a responsible judgment is entered. So it's here it's just enforcing the status of it.
Mr. Brown, just a minute. All right, we've been dealing with this property for years. And they've been at this for years. And these were a couple issues in October and one in December. And according to the city, I haven't seen anything. Apparently, he just sent me some pictures.
These are today, and it's the same as it was back in, and there were some originally attached.
I couldn't find them.
I can resend them. I mean,
I couldn't find them in any of the 3 files.
Okay.
I don't know if they somehow got in someone else's, but I don't have anything in any of the 3 files except the tickets.
Okay.
All right, well, let's hear from you, Mr. Brown.
I'm guessing if they got them just this morning, they probably haven't gotten to email yet.
Well, that's today's photos. Those photos are as it sits today.
Well, I haven't got them yet.
Okay.
So, Mr. Brown, what's the circumstance here?
Don't even know exactly what we're talking about, sir. You're talking about the Chad, if you will. I was told that when I put the other exterior product on it, it was fine. It brought up to compliance. Now we've had some thunderstorms and wind and some tornadoes since last year. So I've had to go back out and repair it, and it's been repaired. It's back to not being a yard-like structure, which the building inspector okayed, because it's the same product I have on my back porch. As far as my view, that is also moving part of this. Not only from the throat cancer now, but from diabetes and disease.
I'm having trouble understanding you. All right, well, you got 3 tickets, and frankly, I can't tell them apart.
Really, I never even think.
All right, just a minute. File 25164ON. You got a ticket on January 7th. Description of offense. Owner was notified on October 28th, November 13th, and December 12th that the property was in violation of section 1105 of the Sturgis ordinance. I don't have that in front of me. After many site inspections and additional time to correct, the property remains in violation. So I can't tell exactly what it is that you allegedly did. Accessory building structures or uses. There's no document in here. Other than that, there's no report, there's no photographs, there isn't anything. So I'm just fumbling in the dark.
He
All right,
was,
the next one, 25165
what's that?
is another ticket. It was issued on January 7th. It says the same thing as the other one. And I can't tell what it was. This one says garbage and rubbish. Then the third citation. That doesn't any help. I don't even have the ticket in that case. All right, so I don't have any facts. Mr. Pritchard isn't here.
He's here, but Your Honor, I guess I'm all of
Okay.
these were issued in normal course of business that we always do. It took the court months to enter the default judgment. That's what the wait was. The court didn't enter the default until April of 25. Mr. Brown never appeared or defended or did anything on the cases. Can I finish talking?
Sure, go ahead, TJ.
Thanks. And so he never appeared. So we have responsible judgments and defaults against Mr. Brown on all of these. So the fact of the matter is settled as far as the law is concerned, as far as he's in violation and in default. We're asking just to bring it into compliance with the city ordinance. Mr. Brown, by his own statement earlier, indicated that he had contact with the city. And the city has been out there a number of times, advised that it's inappropriate and wrong. And that he's got an illegal driveway is one of them. I think that the court was looking for zoning ordinance violation, the illegal driveway where he's parking on the front, in the yard, driving up over the sidewalk. And the photos that were sent today, as it sits today, is the same way it sat when the citations were originally issued and the summons and complaints were sent.
Because the city won't let me put one in.
Those
Mr. Brown?
that's still there.
All right.
Still there.
Court administrator isn't here. The defaults entered May 23rd. The tickets were issued. Defendant didn't respond. And so I can deal with all that. I'm just struggling as what exactly the violation is. Now, apparently, you just sent me some photographs.
So the three violations, Your Honor, I can step through. You'll see that vehicles are parked up and over there. Essentially, the city has a driveway ordinance. You can't just park all over your yard. You have to have a driveway, and it has to be of a certain material, and it has to be in certain locations. Clearly, the property is not being used.
All right. Which citation is that?
I'll give you the file number. It's 25165ON is the violation for illegal driveway.
Okay.
Okay, so that is the illegal driveway.
All right. What is 66?
66 is the zoning ordinance violation for garbage rubbish on the property, which is the standard term for having junk and garbage around the property that needs to be removed or screened.
All right, garbage and rubbish. And then the 6-4 has to do with an outbuilding.
It's a tarp-like structure that's on the property that is not a proper outbuilding. There's no permitting for it, and it's inappropriate, and it's in violation of the zoning ordinance. You can't have it.
Local. And I was told that I brought it into compliance. Your Honor, if I may.
All right, well, is Mr. Pritchard there with you?
I'm here.
All right. Mr. Pritchard, would you please raise your right hand? While we're at it, Mr. Brown, why don't you raise your right hand? You all swear or affirm any testimony you're about to give in these matters will be true to the best of your knowledge and belief.
I do.
All right. All right. Here is a photograph. Is this 800 Mechanic Street?
It is.
And did you take this photograph?
I did.
And you took it yesterday?
Nope, just this morning.
This morning. All right. And is it a fair and accurate picture of the way it looked this morning?
Very accurate way it looked this morning.
Yes.
Yeah, speak up.
Yes.
All right. And is Mr. Brown's property to the right of the picture with the
His
trailer and the truck? Now, there's a structure there with moss or plant growing all over. Is that part of Mr. Brown's property?
Yes, it is.
Garage.
Oh, my. All right, so there's two trucks, a camper, a trailer, and another car. All right, and this is a photograph of the Sonoma that's parked there in the driveway with Indiana plates.
Yes.
That's not a good reflection on General Motors vehicle quality. Michigan rust. There's another picture. I can see here some sort of tarp structure. Is that accurate?
No, that is not tarp.
Yeah, the city has approved that in the past. That's some kind of screen material on his back porch.
That's
Okay.
yeah.
That's
All right,
the
so here,
structure.
is this the building you're concerned about?
Yes.
That is the same material that is on the back porch.
All right, then we've got these trucks, a camper. What are we seeing here? Just a side view of the house?
Yeah, that's just the south side.
And
Another
this
view from the
white,
south side.
this white Buick, is that on the property as well?
Oh, that's my neighbor.
No, you can see
That is
the
It's in this property.
You can see the curb. You can see the curb cut on that, Your Honor, where that is an actual driveway.
Okay. And then there's another view of the house. Does the motorcycle go with Mr. Brown's house or the property next door?
It's Mr. Brown's.
All right.
And we're not sure if that, I think it's a crossfire there, runs or not either.
It runs.
All right. Mr. Brown, do you acknowledge that's pretty much the way your property looks this morning?
Yes, it is. The Sonoma belongs to their home health. It has a motor point out. He doesn't realize he's not supposed to park there, but that's my.
I will admit, this photograph says plaintiff's exhibit 1.
Thank you.
I agree with all the pictures. I agree with all of them. Not disputing. That is my $40,000 Dodge pickup truck.
All right, Mr. Brown, sit down for a minute. Get situated. With your throat cancer, it's hard to hear you. So plus you're breaking up. So tell me what you want me to know.
Sir, I've tried to work with the city for the last 2 years.
I can't hear you.
Fine, my sir. I'm going to everything down.
Mr. Brown, are you using a phone?
Yes,
All right, I'm having, the way you're holding it, I get like every other word. You sound like Charlie Brown's teacher. Plus you're moving around so much I can't see you.
well, I'm trying to talk into the phone better so you can
Okay.
hear me.
All right.
You tell me what's better.
All right, it's better now.
All right, sir. I've had been trying to work with the city for a couple years. Everything kind of started when my home was broken into by Michael Harker, and the home was bombarded with pepper spray, mace, and so on. I've had to do the repair myself because the insurance company chose not to cover it. I've told the city and tried to work with the city. I have health problems and they are getting worse. I'm not trying to be a jerk. I'm not trying to be a combative. I'm simply slowing down severely. I have spent a lot of money cleaning up this house after, 60 plus canisters of pepper spray and mace were shot into it. It has caused me health issues. I have bought another home in Constantine on the river. It is my desire to get moved out of here into the city so we don't have to. But I am one man, and I also have a huge amount of medical visits that I have to make in Calgary, and it's physically taken hold on me.
Is this the same house that had the fire in it?
So
Or is that a different property?
that was my home
That was on-
on County Field. This is my father's home,
There's a different house, Your Honor, that had the fire.
but
It was a different house that had the fire.
yes, it was a different house. This is my father's house, which is still in probate, which I technically don't even own. I'm just in charge of the estate.
All right, so this,
We're hoping to have probate done in the next 30 days. So we can get rid of it, sell it. We've been remodeling it.
so which house is in probate? This one?
I am the executor of the actually.
Now, let me stop you for a minute. Mandy Allen told me 2 days ago she was living with you at this address. Does she reside there?
That one more time. Randy Allen, what?
Mandy Allen told me that she lived there at this address with you,
Temporarily, he was.
but she's not now. She told me that was her address.
Oh, I have a trailer or something that she actually lives in. But she has come here and helped me. Said I have cancer.
Well, that's sort of a side issue, but obviously this place is a mess. You're overwhelmed by it. Well,
not a mess. Got a lot of money. Yes,
all right, well. All right, go ahead.
oh, never mind.
All right, that's it.
Well, you're calling my house that I've spent $80,000 remodeling a mess and a pigsty and all these. And I didn't even cause 90% of the problem. State of Michigan, police and surface police in it. But so be it. I'm just trying to do what I can out of here, get this out sold, and move on. I have told the city this. I have begged the city for some understanding. Yeah, this is not the best up piece of garbage. Yes, there is some clutter. I understand that. But I'm trying to get it moved. But I am one man. And I've got no help from anybody. And I get told by the city, as long as you're moving forward, we're okay with it. And then Officer Dwight shows up with 5 tickets 3 days later.
Well, that was October. It's now July, and so their time frame is different than yours.
No, it's not. It's been taken care of, and then it comes back. I put up a temporary structure take care of the mess. And then, like I said, I don't know if you've ever had cancer, but it doesn't go away in a week.
Yes,
Your
it
Honor?
doesn't.
Your
Yes.
Honor, I think if you pull that picture back up, what Mr. Brown may be conflating is the issue of the interior remodel, which we are not at all talking about the interior of the house or any of this build. That's not at all what this is about. The issue here is, in my opinion, fairly straightforward. It's removing the vehicles that are parked on the yard that are inappropriately parked in a non-driveway spot, removing those vehicles and removing that tent structure that is in the backyard. If you go down, if you scroll down that tent structure, but right, you can see where the sidewalk is already starting to crack, break there. And if you go down, I believe another photograph, or maybe it's up, I'm sorry, where there's a picture of the washout that's starting right behind that Sonoma to the lower left from where you're driving on and over the yard. And that is a city terrace. So if those vehicles are removed and not put there, and that tent structure is taken down, that's what we're talking about. This isn't exorbitant amounts of money or repairs that we're asking Mr. Brown to make to the property. We've not cited him for any other type of structure where he's going to have to put a roof or siding or windows. This is simply get those vehicles off of the yard, stop using that as a driveway because it is not, and remove the tent
Making a
structure.
driveway was confused. I tried to put a driveway there. And I was told by the city I couldn't. I had to bid and everything for it.
There's an ordinance that controls where and how driveways are constructed and where they can be. There's a zoning ordinance that applies to that. So
And I tried to ask him if I could remove the old one to put the new one in the spot. But like I said, I'm 30 days. I promise you, it'll all be gone.
well, if he says 30 days, if we get a compliance order that if it's not done within 30 days, we can go remove the root, remediate the problems, we're fine with that. That's what we asked for at the beginning of this hearing.
It doesn't matter.
All right, you may have it. Mr. Brown, you got 30 days to remediate these issues, or the city will come in and do it and spread the cost on the tax roll. If you want to sell a place, I guess it needs to be brought into compliance before somebody else inherits this problem. But I understand that it takes a while for these properties to get in this condition. It doesn't happen overnight. And consequently, the cleanup doesn't happen overnight, but you're not moving at a pace that the city's satisfied with. So you've indicated you could remedy this within 30 days. And I'm
Promise
gonna
you.
the city to present compliance. In fact, 30 days from today would be August 10th. I'm gonna give it to August 15th.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Or the city can do it and give you the bill. They put it on your tax roll. There's also all the unpaid fines from the civil infractions, which we're not gonna get into right now.
We settle that.
So, all right, Mr. Reed, you can present an
Can we
order.
settle that
Just
now?
as an aside, Mr. Brown, I've been dealing with Mandy Allen. I want to make clear, she's not welcome to reside at your house.
Okay.
Mandy Allen, she says she lives at your house. But does she live there or not?
She has a significant other does not reside here. So it's kind of an in back and forth kind of thing. She's welcome here as long as she's doing what she needs to do. She's doing.
Well, she's not. So, all right, she's welcome there. I'll leave it at that. Okay, Mr. Reed, you can submit a compliance order. Mr. Brown, good luck with your buying a house in Constantine. You got 2 distressed houses in Sturgis you'd like to get rid of. Get over there.
I only have one house.
Oh, the other house is gone, the one that was burned?
Yes, I told that. I told the property I've leveled it out, cleaned it. Yes.
All right. All right, we'll await the compliance order, see what you can do between now and August 15th. As Mr. Reed said, this isn't that hard to fix. You're gonna have to find a place to put those vehicles, which isn't on your lawn. But with that taken,
Or
tent
don't get me
structure.
wrong. The only reason I park in the yard is because physically can't walk distance in the street or the driveway. I just can't. I'm physically unable to do it. That's why I've been parking. That's why I wanted to put a driveway in. But I
No, they
couldn't
won't
get,
let you put a driveway right there, so,
you know,
all right, Mr. Reed, I'll await your order. Thank you, Mr. Brown. Good luck to you, sir.
I was able to-
Okay, we'll await the order. He was complaining that the date for the default took so long.
Yeah.
No response or answer by February 25th. Default entered February 28th. Judgment entered March 12th.
I was gonna say you should have kept TJ Reed up there.
Oh, yes, well, Tim already did it. So where is this human you were talking
So
about?
she's in Judge Patterson's room right now, like about to end her pleading.
Oh, so she's doing things next door?
Well, only the statute, not the ordinance. Cause Judge P, it's Judge P.
All right,
So
well,
do you want me to tell security to bring her in here? 'Cause
yes,
it should all be in your queue. And I'll get you the pre-trial sheets.
all right,
Thanks, Judge. I
thank
appreciate it.
you. This ended up being way more complicated than it needed to be, but I'll take care of it. James was here the other day and I set both of these matters for pretrial this morning, but somehow it got very complicated. Judge Pattison did one of the cases and they've asked me to take care of this ordinance case. Mr. Tim George, the Sturgis City Attorney, said we will dismiss one trespass, the old one, if she pleads to the new one and recommend time served. I think altogether you've got about 5 days of jail credit.
Yes.
And I think I even have some bond money. Let me look. Now, the public defender, Mr. Stickley, isn't here because he's next door and he can't be two places at once.
Sir, actually, Judge Pattison is done. You can have keep him over here if you want.
Is he available?
July 22nd. Well, we're not gonna be able to get it back because that's not 2 weeks. It's gonna have to be July 31st, 2025, 9 AM. Bond on all of these matters will continue.
Thank you, Judge.
What is that date again? If you can please repeat that.
It's July 31st,
And what's
9 AM.
9 AM? Thank you so much.
All right, got it?
Yeah, thank you.
Thank you. Court does call the case of the people versus Rio Boyd.
So Mrs.
And on behalf of the people, Your Honor.
Particular on behalf of Ms. Boyd, would you state your name for the record? Oh, sorry about that.
Rial Boyd.
Judge, I was just appointed, I think yesterday, may we get a short adjournment?
Probable cause conference will be adjourned July 22nd, 2020. 9 AM. Bond continued.
July 22nd. Thank you,
That's
Judge.
Tuesday. Thank you.
Thank you.
Court does call the case of the people versus Duran Wilburn.
Alexander on behalf of the people, Your Honor.
Edward Lucas on behalf of Jerome will be approaching.
And good morning, Ms. Lowe. Just because you think that you're a small walking past, I could still see. Your name, sir?
Ron Wilburn.
Thank you.
Your Honor, at this time, discovery is complete to my knowledge. I'm asking for a preliminary examination.
$20. Would the people have their witnesses available the 22nd?
We'll do our best, Your Honor. And I did want to make clear aware as well, we did request a 911 call on the 9th, so it should be here before exam.
All right. Preliminary examination in person, July 22nd, 2025, 9 a.m. That is before
Judge Barr.
Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Deja Moore.
I'm here.
Good morning, Your Honor. Christina Costantino appearing on behalf of Ms. Moore. Ms. Moore, can you please unmute and state your name for the court?
Deja Moore.
Thank you, ma'am. Constantino, you just don't come to like Washtenaw County anymore?
Judge, I love Washtenaw County. I would much rather be there with you than where I've been. Trust me on that one.
Okay. All right. Well, everybody else misses you. I know. All right. What are we doing? What are we doing?
Judge, I did just recently receive some new discovery this week. I would like a chance to review that with my client. So we would be asking for a brief adjournment of the PCC.
All right. We have some strange dates. Would you like Tuesday the 22nd or the 31st?
The 22nd would work.
All right. Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Right. Thank you. It does call the case of the People versus Isaiah Bozeman.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bozeman. You sir, state your name.
Isaiah Bozeman.
All right, what are we doing?
We're requesting an adjournment to review discovery.
Are you? It's not signed, but are you aware of a character reference letter sent on his behalf?
I don't have that, Your Honor, no.
All right, I'll make sure because since it came to the court. Yeah. That come with it.
Something to you somewhere.
I don't know why they're here. There's a number of them sent for whatever reason that is not going to have an influence on the court, but we'll provide those to both parties.
Thank you, Your Honor.
All right. You're asking for an adjournment of this matter. I'll adjourn this matter. Probable cause conference to July 22nd, 2025, 9 a.m. Bond continued.
Your Honor.
Court calls the case of the People versus Heather Booth.
People.
Mr. Rushing?
Oh, correct.
Good morning, Your Honor. Sydney Rushing appearing on behalf of Miss Booth. Is that Miss Booth in the Wayne County Jail by chance? That's where she is currently located, Judge.
Do you have her?
We did not know she was in custody.
We did not know. So I'll have to kick this out to the 31st. So we have the 2 weeks for a writ if she's going to be there.
Your Honor, she's on remand status, so it's my understanding that she's likely going to remain there till then.
Okay. Probable cause conference, July 31st, 2025, 9 a.m. Bond continues.
Thank you so much, Your Honor.
Thank you. Court does call the case of the people versus David Mariquin, 2 cases.
Your Honor, Alex Warren Green on behalf of Mr. Mariquin. You state your name?
David Merrickman.
Your Honor, at this time, we're asking the court to set both matters for preliminary.
All discovery is complete.
Discovery is complete, Your Honor.
People have their witnesses available the 22nd. Preliminary examination in person in these matters will be set for July 22nd, 2025, 9 a.m. 9 or noon.
It's actually at 12.
12 noon
With you.
for me. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Todd Amerman.
I'm Lori Gacky, Assistant Public Defender with and on behalf of Mr. Ammerman, who is standing to my right.
Your name, sir?
Todd Ammerman.
Your Honor, I do apologize. I will 100% take responsibility. We do have a plea form. I know I should have submitted it yesterday. Mr. Ammerman was very diligent in calling my office and we were only able to connect after. But we have agreed upon a plea. It's not a no contest plea, it's just a guilty plea to an added count 2 abuse. So I'm hoping the court will take this today.
Plea form indicates that the defendant will be pleading, that box was a check. He's pleading guilty.
Yes, I apologize.
That's what happens when we rush things at the last minute. The plea form indicates that he's going to be pleading guilty to the charge of use of methamphetamine. On his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Todd L. Ammerman.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Do you understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in 1484 District Court.
Yes, sir.
Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
Has he signed an advice of rights form?
I
You're not ready. I'm passing it.
okay. I'm sorry.
Court calls the case, people versus Zavratko. Get enough, I think.
Good morning, Your Honor. Warren Wilson, on behalf of the people.
Good morning, Your Honor. Roba Hamden requesting permission to practice pursuant MCR 8.120 under the supervision of Assistant Public Defender David Boundary.
Permission practice is granted.
Thank you. I am here with on behalf of the Grappo Kitnell. Can you please say your name for the record?
Sure, good enough.
We are requesting a 2-week adjournment on this matter for negotiation.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case of the people versus Anita Barnes.
Assistant Public Defender Nicholas Bukovich on behalf of Ms. Bonds, who should be appearing via Zoom.
Anita Barnes.
Got her. All right, what are we doing?
At this time, Your Honor, we'll be requesting a 2-week adjournment for a bit of further negotiation, and so I can provide some documentation to APA Cook. And I do have a green sheet.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Ms. White. Court does call the case, People versus Anthony Alfaro Tejas.
May it please the court, Your Honor, good morning. My name is Venu Yadala. I appear on behalf of Zachariah Bonham, who is the attorney of record.
Oh. See here.
I'm sorry, Your Honor.
He's in custody.
Hey, how you doing?
Your name, sir?
Anthony Alfaro Calles.
Thank you. All right, what are we doing?
Your Honor, my understanding is that counsel just submitted a substitution and needs time to give discovery review with the client. So I believe they're requesting an adjournment.
Your Honor, that is a fair and accurate statement. Negotiations are being continued. We would respectfully request a brief adjournment.
They didn't tell you anything about green sheets. You'll need to fill out the green sheets. I'll grant the adjournment. But will the 22nd be enough time, counsel?
Thank you.
Will that be enough?
That should be enough. Thank you.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Roderick Bates.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bates, who should be appearing via Zoom.
Good morning.
Your name?
Roger Bates.
So, Your Honor, the prosecution's recently provided some additional video discovery we were just able to get from Washington County. So I just need time to review that with my client. So I'm requesting an adjournment.
Probable cause conference. Do you have a green sheet for me?
Yes, I do, Your Honor.
July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of People versus Molly Fox.
Good morning, Your Honor. Ellen Dennis appearing on behalf of Molly Fox.
Your name?
Molly Fox.
You're requesting, well, is she gone to inpatient treatment yet?
She hasn't gone, she's still in custody, Your Honor. You
I know.
signed the order yesterday, I think. And it has some contingencies in it that there has to be a bed. She believes there will be, but we don't know yet. Also, I could tell the court that she's been interviewed by Mr. Reyes with a review of whether she'd be eligible for recovery court. And I do not know what that decision is because I haven't received the email yet from him. That happened, was it yesterday? Day before yesterday? Tuesday.
Your interview happened day before yesterday?
Yeah.
Okay, they should be coming out, hopefully with a decision relatively soon. I can give you the 22nd or the 31st, counsel.
Pardon?
The 22nd or the 31st, which date would you prefer?
The 31st. Now, I assume that if the bed becomes available, she can go and still.
She'll be an inpatient and we'll deal with it, but I mean,
okay.
I'm not gonna hold everything up on that. Probable cause conference, July 31st, 2025, 9 a.m. Bond continue.
Thank
you.
Your Honor.
Court calls case People versus Elton Bell.
Good morning, Your Honor.
Kerma Dadush on behalf of Mr. Bell. Mr. Bell, can you please state your name for the record?
Elton Robert Bell.
And good morning, sir. All right, what are we doing?
Your Honor, I did submit a green form, but we are actually not going to be adjourning on this case. We are going to be waiving preliminary examination.
All right, Mr. Bell?
Yes.
You're gonna waive your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
And you understand you'll not have that hearing. You'll proceed to circuit court for further proceedings.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over on a single count.
We waive formal reading of the charges and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 28th, 2025 at 1:30 with Judge Slay.
August 28th, 2025, 1:30, Judge Slay.
Thank you so much, Your Honor.
Thank you, Your Honor.
Bond will, thank you, sir. Bond will continue. Court calls case People versus Ardeen Henderson.
Everyone.
Ken Madadush on behalf of Ms. Henderson. Ms. Henderson, can you please state your name for the record?
Yes, my name is Ardeen Beatrice Henderson, Grand Rising. Thank you all for having me.
You're welcome.
Your Honor, we are going to be asking for an adjournment. We have just started a mitigation process. So we're going to be asking for an adjournment for that purpose and plea negotiations.
Your Honor, I would just remind the court, Ms. Henderson does have a case in Wayne County. She's got a case at 35th District Court, where she's referred for competency in May. That court has not come in, based on from actions. And that court is for August 29th.
August 29th. So were you aware of that, counsel?
Yes, I was. She had told me that she started that process.
Okay, well, then I'm a bit reluctant to do anything prior to that competency report coming through. So
Are we able to adjourn further out?
I'm able to do a lot of things. Some of the things I will not do.
Whatever Your Honor prefers.
Of course, you're learning. Give me a September date.
September 11th.
September 11th.
Can she hear us?
I will adjourn. Can you hear me, ma'am?
Yeah, I just don't understand what's going on. Can somebody please explain to me, please?
Okay, so I'm adjourning it out. Okay, my understanding is that there's a competency review in your other matter.
Okay.
Okay, so
Okay.
what we're doing is we're taking the safe course of this, putting this out till after there's a finding there, because that may dictate what happens here. We really can't get much done until that comes through.
Okay, well, my lawyers better explain to me later also again, I won't forget, or can someone send me something or something if I can have someone read to me what's going on? Okay, never mind. The sergeant here said, Sergeant Perzon, how you pronounce your name? Porzondek said he'll help me. He explained to me.
Okay, and your attorneys will be in touch with you, okay?
I can talk to you next week, Ms. Henderson, okay? To explain all of this.
Thank you.
Okay.
I thank you all for having me.
Yes.
Okay,
we are so glad, and we will
thank
have you
you.
back in September 11th, 2025 at 9 a.m., okay?
Take care, Ms. Henderson.
Bond
For
continues.
my birthday, and what day would, I'm
That's
sorry,
your
what day
birthday?
would that be?
September 11th.
September the 18th, it's right before.
September
That's on a
18th, your birthday? Well,
Maybe
so I
Yes.
don't forget, happy birthday.
Thank you. I'm taking my grandkids to the water park before it gets cold. Thank you.
Okay, take care.
Thank you.
Court calls the case, People versus Orby Huffman. David Burgess on behalf of Orby Huffman. State your name, sir.
Orby Huffman.
Thank you. What are we doing?
Your Honor, we've received discovery in this matter. We're requesting an exam be scheduled.
People have their witnesses available the 22nd. Preliminary examination in this matter will be set for July 22nd, 2025 at 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond will continue. Thank you. Does call the case of the people versus Nathan Bell.
Assistant Public Defender Nick Bukovich for Mr. Bell, who should be appearing via Zoom.
Nathan Bell, do we have him?
No, I do not.
I was in contact with my client this week and he asked me to put in that Zoom request.
He did?
Yes.
I'm here.
So,
I'm here.
He goes by another name, Motorola. Sir, I
Yeah.
need you to turn on the camera, please.
Yes, sir. Yes, am I here? Yes, I'm here.
Okay, you have to uncover the lens. There you go.
there you go.
What's your name?
Nathan Bell.
All right, what are we doing?
I'll be requesting a brief adjournment for Mr. Bell to obtain some medical documentation I can provide to the prosecution towards an offer. And I do have a green sheet, Your Honor.
July 31st, 2025, 9 a.m. Bond continued. Court does call the case People versus Jonathan Miles. Oh, there she is.
Good afternoon, I'm sorry, good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning.
And Alex Warren Green on behalf of Mr. Miles. Mr. Miles, can you state your name for the court?
Jonathan Dion Miles.
All right, what are we doing?
Your Honor, I had an opportunity to confer with the Assistant Attorney General. She did extend a generous offer, but at this time, Mr. Miles is asking for a preliminary examination.
I'm sorry, who in our office did you speak to?
I emailed you, Ms. Williams, and received a return email as well.
Okay. I don't recall that, but okay, I'll look through my emails.
All right. You want this set for exam?
Mr. Miles is asking for a preliminary examination, yes.
All discovery is complete.
Believe so, Your Honor.
Would the people have their witnesses available on the 22nd?
We should, Your Honor. I'm sorry.
All right.
What is the defense attorney's name? He's saying he sent this email. I don't remember having a discussion. Was this shortly after the last hearing about this case? I know we hadn't made an offer at the last hearing.
My name is
Yes.
Alex Warren Green.
Okay. I'm not saying that you
received a
did.
No, I get you. How much is owing on this?
Your Honor, I believe it's just north of $6,000.
And so the exam is going to be over what's owed?
Your Honor,
Meaning the law that if it's charged, it's owed?
Talk to my
That's
client.
okay.
I advise
We'll
I
set it.
advise him of the offer.
We'll set the exam.
Thank you.
Preliminary examination in this matter in person will be set July 22nd, 2025. That's at 12 noon. And that's before me.
Thank you, Your
If
Honor.
we set it for exam, Mr. Warren Green, you better come with something.
Thank you, Your Honor.
Court calls the case, People versus Daniel Bowe.
Assistant Public Defender Nicholas Bukovich for Mr. Bowe, who is approaching.
Your name?
Daniel Bowe.
Thank you.
At this time, Your Honor, we requesting a brief adjournment. The prosecution has extended an offer It's just, Mr. Bo wants to confirm that this offer won't have impact on an outside matter before accepting it. So,
Probable cause conference, July 22nd, 2025, 9 a.m.
Mr. Bo did want me to ask if we could do a possible further out adjournment because he'll be up north for work from July 19th to August 5th. I did explain to him I could ask that, but it's only up to the court.
Yeah, I'll be up by Mackinac working for about 2 weeks. And I don't want to miss court and have anything come back on me because I'm 4 hours away. If I have to make that adjustment, I will, but I'm just asking.
Oh, I know. When are you coming back now?
August 5th, I'll be back.
Any objection from the people?
No, Your Honor.
Thank you.
August 7th, 2025, 9 a.m.
Thank you, Your Honor.
You're welcome. Bond continue.
Thank you, Your Honor.
Calls case people versus Noah Adamson.
Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Adamson, who's approaching. Could you state your name for the court?
Noah Adamson.
Thank you.
Your Honor, we are respectfully requesting an exam be set in this matter. The only
All
outstanding.
discovery, go ahead.
No, I'm sorry. The 911 call has already been requested and should be here either today or tomorrow.
That's correct, Your Honor. And if we could address bond appropriately.
Preliminary examination in this matter will be set July 22nd, 2025, 9 a.m. That will be before Judge Barr. As to bound.
Your Honor, it's come to my attention that since arraignment, the defendant has made 37 calls to the victim in this case, and at this time we would be asking that his phone privileges be revoked.
Where'd you go? Oh, no. Response.
Your Honor, unfortunately, we don't have, the calls, we don't have the timings. I can't really respond without having the information underlying the argument. Mr. Adamson actually wanted me to make a bond argument today for his release, as this is the only case holding him, and he has to go back to work. He has a separate residence from the alleged victim. I will have a conversation with him about ensuring that he understands and will comply with the no contact order. I know he's been contacting his family and friends using the phone here, as he has a lot of kind of business to attend to on the outside, and his rent's coming up and all that. So I would ask for the court to reserve judgment until the exam date in terms of his phone privileges.
These are to the victim's number.
Your Honor, I believe so, Your Honor. Yes.
They are. So, Ms. Yagi, are you making a motion to reduce his bond? I mean, was that what I was hearing or not?
I am, yes.
Go ahead, response.
I would object, given the phone calls. I believe the defendant is also currently on probation for a previous conviction in circuit court for a GBH DV act the same victim that he was sentenced on, I believe, in February of this year. In this case, they had an argument. He grabbed her by the wrist, pushed her up against the wall. She was able to free herself, tried to use a roommate's phone to call 911. He takes the phone, hangs it up. She then tries to call 911 from another phone. He then takes that phone, hangs it up, and he entered the apartment to begin with without permission. I have concerns given that he is on height of probation for a DV offense with the same victim from this year and is engaging in that same behavior. Would ask that bond remains the same.
Anything else?
I just want to note that that there's no hold for that case, and we discussed the tether. He's in accountable choices. He's in contact with his probation officer and hasn't been violated yet. So, but nothing further, Your Honor.
Defendant's motion for bond reduction is denied. As to people's requests as to the revoking of his phone privileges. This time the court will revoke the defendant's phone privileges. Defense is entitled to and can request a hearing on that matter once they hear the calls.
Thank you, Your Honor.
Court does call the case People versus Kevin Burden.
The Assistant Public Defender Jay Zollinger on behalf of Mr. Burden. And Mr. Burden, can you please state your name for the record?
Kevin Burns.
And Your Honor, all mitigation materials have been submitted. We're just waiting on consideration of that. We would be asking for 3 weeks.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus De Jure Bond Sanders.
Alexander on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Bond Sanders. State your name, Mr. Bond Sanders.
Deja Bond Sanders.
Thank you. Your Honor, we're asking for a preliminary examination in this case.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available the 22nd.
I believe so, Your Honor. And for the rest, we did request a 911 call in this case. It has not come in yet, but it should be here by Monday before.
All right. Preliminary examination in person, July 22nd, 2025 at 9 a.m. before Judge Barr. Bond continued. Court
Your Honor.
Court calls case People versus Andrew Burke.
And Alex Warren Green on behalf of Mr. Burke.
Your name, sir?
Andrew Burke.
Thank you.
Your Honor, today's date and time for probable cause conference. At this time, Mr. Burke does wish to waive his right to a preliminary examination and proceed to circuit court. I'm having him sign the waiver right now.
Mr. Burke, while you're signing that, you're waiving your right to a preliminary examination, sir?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, I do.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
I do.
All right. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 28th, 2025 at 1:30 for Judge Slay.
August 28th,
Yes.
2025, 1:30 before Judge Slay. Bond will continue. Court calls the case People versus Matthew Fonseca. What's the deal on this one?
So he has a bond violation, this one. Oh, I'm sorry.
That's
Good morning, Judge.
Good morning.
How are you? Brian Bowling.
I don't know. What are you gonna do? No, go ahead.
Good point. Brian Bowling on behalf of Mr. Fonseca, just state your name for the record.
Matthew Fonseca.
Your Honor, when it comes to the PCCs, we were in the process of trying to reach a global resolution, but now it's come to my attention, there is a new charge that we will kind of throw into that pot to try to put it together.
Absolutely, and I'll arraign him on that charge. Mr. Fonseca, you're here on another case.
Your Honor.
Find my complaint.
I was able to obtain a copy of the complaint this morning. I did review that with Mr. Fonseca, so for purposes of the arraignment on that charge, I would waive formal reading and stand mute.
Mr. Fonseca, you understand the nature of the charges in that case?
Yes, sir.
You understand the maximum penalties?
Yes.
And you do wish to be represented by counsel?
Yes.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. So in terms of setting the probable cause in this matter.
Well, Your Honor, this would be, I guess, Now, 2 felony matters, it looks like that would be pending.
This doesn't have to do with dates. Okay. All right, go ahead.
We do have the bond violation as well. That
Yes.
is alleged. I guess obviously.
Which are different than the new charges.
Correct.
But
So, I mean, I guess if we just could keep everything together and have a
Yes.
couple weeks, I think that would be satisfactory. I should be able to get a discovery request submitted today, and hopefully we'll have those materials prior to the next.
I'll
meeting.
adjourn then everything out. I'll adjourn the one that's set for PCC as well as the bond violation hearing. I'll adjourn that to the 22nd, 2025 at 9 a.m. Bond will continue on that matter. On the other matter, I will set the probable cause conference for July 22nd, 2025, 9 a.m. His bond in that case. What's his bond in the other one? So how many cases is he being held on right now?
It is just the bond violation, correct? Because you were out of custody, right?
Yes. Bond in this case will be set at a $5,000 cash surety at this juncture. I'll order standard conditions, including no assault, possession of any weapons, no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I will order that if the defendant is released, he is to report over to community corrections for 2 times per week drug testing.
Thank you, Judge. Your Honor, on the matter pending with the bond violation, was bond revoked?
It was.
Okay. Thank you, Judge.
So his bond will be revoked on that matter. Correct.
Okay, what time do I have to go back?
I'll be over to see you.
Pardon? Court calls the case People versus Antonio Williams.
You took the people. Brian Boley on behalf of Mr. Williams. Oh, he's on the screen. Your Honor.
Mr. Williams, do you have somebody that can unmute? So you can tell us, can you unmute the device?
Judge, he can hear you, but he's basically blind. So
okay.
He won't be able to, move around within that room to.
All right, Mr. Williams, if you can hear me, if you can wave your hand so that I know that you can hear me. All right, thank you, sir. What do you want?
Judge, after meeting with Mr. Williams at the jail, I believe that a competency examination is appropriate in this matter, so there should be a proposed order in the court's file for that. I'd ask you to sign it.
All right, I will sign those orders for a forensic evaluation ordered. I'll set a competency hearing for 90, please.
October 9th,
October 9th, 2025, 9 a.m. Bond on this matter will continue.
Thank you, Judge.
Court does call the case People versus LaShawn Charles.
And Laura Yagi, Assistant Public Defender, with and on behalf of Ms. Charles. Ms. Charles, can you state your name for the court?
LaShawn Charles.
Got her.
Thank you. Your Honor, we're asking for an adjournment for further discovery in this matter.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Have a good day.
You do the same. Court calls the case People versus Darrell Frederick.
Assistant Public Defender Jay Bellinger on behalf of Mr. Frederick, who approaches.
Ms. Wyman.
Mr. Frederick, can you please state your name for the record?
Frederick.
Go ahead. And Your Honor, we've signed a waiver and I got my client's permission to sign that on his behalf.
Oh, sure have. All right. So you're waiving your right to a preliminary examination?
That's correct.
All right, you understand that's a proceeding where people would have
To whatever you were talking.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
That's correct.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
That's correct, Your Honor.
All right. People also waive their rights. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We have formal reading stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 22nd, 2025.
July 22nd, 2025, 1:30, Judge Comfy.
We'll be in touch, okay? Thank you, Your Honor.
Thank you. Bond continue. Court calls the case, People versus Bradley Chavez.
On behalf of Mr. Chavez, can you state your name for the record, sir?
Bradley Chavez. All right.
We are going to be asking for a brief adjournment so we can continue plea negotiations with prosecution.
Probable cause conference, July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Bond continue. Court calls the case, People versus Robert Gallet.
Kerma Dadush on behalf of Miss Gallet on the case ending in 713.
Morning, Roger Kilwell, Judge. I'm on case 5612.
All right.
Your Honor, we were going to be asking for adjournment in our case and a chance to address bond, please.
You're also asking for an adjournment.
Yes, I'm sorry.
All right. Go ahead and address bond.
Thank you, Your Honor. First of all, Ms. Gallet here wanted to apologize for missing her last court hearing. Since the start of this case and since her last court date, a lot of things have changed. Ms. Gallet has, first of all, now she has a phone that we can contact her on. She has gone back on her medications. She has bipolar medications that she has to take as well as hormones. So all of that kind of, well, it can, not, I don't want, let me word this correctly. All of that is helping us reassure, we're using that to help reassure Your Honor that she is going to show up if she is released on her own personal recognizance. She has also, she has two different caseworkers helping her. She has a CMH caseworker and a PATH caseworker. She has been approved for Avalon housing if she were to be released. So all of that combined her having a more secure home, having a phone number and medications. We are hoping to get a personal recognizance for that reason. She will appear, she has no intent, and there is nothing else holding her. I believe she has a 15th district court case, but that she has a PR for that.
How did she come back in custody?
On the 15th case, Your Honor, 15th district court case. Which is just a Parks violation.
When did that happen?
I believe on the 4th or the 3rd, July 3rd. Well, that was the day.
So between March 20th and that time, what was she doing?
She was unmedicated. Her husband he also has bipolar and schizophrenia. They were both unmedicated. They were both homeless, doing quite poorly. Since then, all of that has changed. Her husband is in custody, but she is really trying to do her best. She, picks up debris with the Parks and Recreation program, Give 365. Again, her meds are a very big part of her ability to, come back to court and be more stable, have stable housing. And she hopes to even start classes with Washington Community College, wants to do linguistics, just wants to start becoming better. And her meds was the first step to that, Your Honor.
Mr. Kilowald, anything?
I would just echo that argument, Your Honor.
Anything from the people? I really don't necessarily need it, but go ahead.
Two sets of concerns. I appreciate that it sounds like there's some progress being made. That case in the 15th district is an assault matter in Echo Hospital. I understand that things have happened in the psychiatric environment there, but that offense was just June 28th. And I'm concerned about some of the behaviors there and wondering, it sounds like there's been a very dramatic turnaround within a very short amount of time. I don't know if Mr. Lucia has anything else to provide proofs of some of the housing. The family is apparently in the California area, doesn't really have any ties to our county either. So I'm not sure, I'm not sure that we'll see her, quite frankly. We do have.
So when I say I don't need it, what does that mean to you?
Well,
go ahead. No, go ahead. I'm listening.
I had options. You told me you asked.
No, I did.
Although you don't need it. So, that's it.
Thank you. Motion for bond reductions denied. Bond will continue. I'll set the probable cause conference for July 22nd, 2025, 9 a.m. in both cases. Thank you. Court calls the case, People versus Deshaun Clifton.
Stephanie Cannon on behalf of Mr. Wood.
Oh, boy. Oh, boy.
And Your Honor, we're simply asking for an adjournment. I'm sorry,
She did? She said her name?
I did.
I didn't hear it.
Oh,
I
you want me to do it
heard
again, Your
I
Honor?
heard- No, really not.
Okay.
Um,
Mitigation information has been provided very recently to the prosecutor in this case. We're just asking for some time, 2 weeks, Your Honor, for her to review it and see if an offer is forthcoming.
Will the 22nd work?
It
for
will,
you?
Your Honor.
The 31st, all right. Probable cause conference, July 22nd, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case People versus Haruska Dennis.
Hannah Mack on behalf of Mr. Huska Dennis, who is approaching.
Again, Your Honor, Christina Costantino appearing on behalf of Mr. Haruska Dennis in the case number ending in 5076.
All right. Your name, sir?
Zachariah Haruska Dennis, Your Honor.
Thank you.
We're respectfully requesting an adjournment in this matter. We AIM sent over a mitigation report last night, and the prosecution needs time to review it.
And I would join in that request.
All right. Will the 22nd work? I think that's what we set your last case, Ms. Constantino. Is that right?
Yes, Judge, I would ask for the 22nd, given he is in custody.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond will continue. And Ms. Constantino, I will tell you, I miss you too. And Mr. Allen told me I wasn't very nice in saying what I said the last time. So I don't know what's going on there, but he was kind of yelling at me.
Well,
So-
thank you, Mr. Allen, and thank you, Judge. I appreciate you changing your mind. I hope to see you soon.
Yes, ma'am.
Thank you.
Thank you. Court calls the case, People versus Christopher Cummings IV.
Assistant Public Defender Chelsea Vergils with and on behalf of Christopher Cummings. Please state your name.
Christopher Cummings.
Your Honor, we are requesting an adjournment today. Since his last court date, we did receive discovery. We're asking for time to review that and consider the offer that's been made in this case.
July 31st, 2025, 9 a.m. Bond continue. Thank you. Court does call the case, People versus Mark Hubbard.
Alexander on behalf of the people, Your Honor. And back on behalf of Mr. Hubbard, who is approaching, Your Honor. Please state your name for the record.
Mark Hubbard.
Your Honor, at this time, we respectfully ask to set this matter for a preliminary examination, and all discovery is complete as far as we are aware.
People have their witnesses available the 22nd.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 22nd, 2025 at
12 p.m.
12 noon before me. Bond will continue.
Judge.
Court calls case People versus Devon Julia Martinez.
Stephanie Cannon on behalf of Ms. Martinez, Your Honor, who is appearing via Zoom.
Devon, can you state your name for me?
Devon Julia Martinez.
Thank you.
Your Honor, Ms. Martinez was recently, I believe, a week or two ago, evaluated by the Forensic Center because in her other cases, she has forensic order requested. I am filling out the paperwork to get one filed in this one as well. However, we have not received the evaluation back. Upon receipt of that, my client is indicating she does want to waive. However, I don't believe the court will do anything.
I won't.
But I want her to hear that, won't be able to do so.
When is that other case set? Do you know?
She is set in front of Judge Hammoud. I believe her next court appearance is on July 28th.
All right. And you're filling out the paperwork because you want, all right.
I'm just gonna have the order placed in this file as well, Your Honor.
So I will order a forensic evaluation. I will set her comp hearing on this case, October what?
October 9th.
October 9th, 2025 at 9 a.m. If the report comes in before then, certainly we can move that date up. All right.
And I will explain that to my client, Your Honor.
All right. Bond will continue.
Thank you.
Yes. And when they get that. Who's filling, thank you. Who's filling out the order? I can really? Oh, it's gonna be a minute here. Why is that taking so long?
Your Honor.
Why, not you, her.
Okay.
What is she doing? What are you trying to help her? Just slowly though, right? Court calls the cases of the People versus Chad Jones.
Hannah Mackey on behalf of Mr. Jones, who's approaching. Please state your name for the record.
Chad Jones. Thank you.
Your Honor, we're respectfully requesting to adjourn this matter pending drug court eligibility.
All right. Has he already been interviewed yet?
Not yet, Your Honor.
Not yet?
The referral was sent in yesterday.
Of course it was. All right. I will adjourn these matters then to July 31st, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Sean Hardman.
Portable 8.120. During the supervision of Assistant Prosecuting Attorney Jennifer Donovan.
Good morning. What? Hold on. So why are you with Douglas? Wow. I asked the question. Actually, what I was going to say, what does Zenda do to you? Oh, okay. All right. No, I thought you might have requested a transfer. Permission to practice is granted. Go ahead.
Good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Hardman. Mr. Hardman, can you please shake your hand, let the deputy know to need to be unmuted and state your name for the record?
Oh, yeah, hold on to that blanket. Just, don't worry about it.
Okay, thank you. Your Honor.
That's him. We're good.
Your Honor, at this time, we are requesting a brief adjournment. There is some outstanding discovery that I will need to get and review with my client. So we are just asking for an adjourned PCC date.
All right. Probable cause conference, July 22nd, 2025, 9 a.m. Bond continue.
Your Honor, may I briefly address bond?
Sure.
I did tell the people I was going to be doing so. Mr. Hardman's bond is currently set at $1,000, 10%. So $100 is what would need to be posted. I'm asking Your Honor to consider reducing that down to a personal bond. This case the incident date is from November 2nd, 2023 The warrant on this case wasn't signed until September 26, 2024, and then the arraignment on this happened on 6/30/2025. He's actually currently in Judge Conkey's drug treatment court. So this isn't a new case. It's not a violation, or I guess I should say it wasn't a violation. It will be if he pleads on, but it's not new. So I'm just asking for your honor to consider reducing it down to a personal bond. He does have stable housing.
Is this the only thing holding him?
Yes. After this, Judge Conkey isn't addressing the bond on that case until this bond's addressed. So he has court on that on the 20, is it the first?
So
I believe on the 26th.
Well, is this a bond violation?
I think at this point, since it's been issued, yes, but she was waiting to see what the court was going to do on this bond before she addressed her bond. He had court earlier this week.
Okay.
She put it out for us to address it here first, and then she's going to address it in her court.
Okay, just so that I have the timing correctly. He was in drug court.
Yes.
This case, the allegations in this case occur.
They occurred prior to him going into drug court. So this case, it took a while for the warrant to get signed. When the
Gotcha.
warrant got
That's what I
signed,
was trying to make sure of. So
yeah,
this case, I'm not clear how it would be a violation. Okay, I get you. That's what I was trying to figure out.
Yes.
Dates weren't matching up for him.
I think technically it can be, but I don't think it's going to be viewed as it since the incident happened prior.
Any response from the people?
It's usually that it's a mobile case, it's not assaultive, so we would leave it in the court's discretion. The incident does predate the other incidents in the circuit court cases, and XGL isn't showing any holds on.
Alan, doesn't she seem much nicer since she's not with Zenda? I say that out loud. I'm sorry, Miss Zenda, I didn't mean it.
They know your case or no?
All right, here's what I'm gonna do. I will, under the circumstances, and since he's in drug court, I will grant the defendant's motion. I'll reduce his bond to a $1,000 personal recognizance bond with all its conditions of no drug use.
Thank you, Judge.
All right.
A few minutes.
All right.
Thank you, Judge. I'll see you on the 22nd.
Thank you.
Have a great day, Judge. Have a
You
great
do
day
the
to staff
same.
as well.
Okay, he's all set. Court calls the case, People versus Nicole McCauley.
Hannah Mackey on behalf of Mrs. Colley, who is approaching.
So in there, you don't have.
Nicole McCauley.
Yeah, you're all set, sir.
We're requesting an adjournment in this matter, Your Honor. We are waiting for media discovery.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continue. Court calls case People versus Stefan Wainwright. Why do I have so many down there? Jimmy.
And Alex Warren Green on behalf of Mr. Wainwright, who is on Zoom, Your Honor. Mr. Wainwright, can you state your name for the court?
Yes, Stefan Dallas Wainwright.
Thank you. All right. Your Honor, I've completed an adjournment request form. We are asking for an adjournment to continue our negotiations with the people.
July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case of the People versus Richard Morende. Morende.
Ally Zend on behalf of the people, Your Honor.
Good morning, Your Honor. Megan McDonald on behalf of Mr. Morandi, who is present on Zoom this morning, and we consent to have this hearing via Zoom.
Sir, can you please state your name?
Yes, good morning, Your Honor. My name is Richard Morandi.
Thank you.
Your Honor, for the purposes of the PCC today, we have not yet received discovery in this matter, so I would ask for an adjournment of this, please.
All right, he's out of custody. So
Yes, he's out of custody on bond.
seriously. I'll adjourn probable cause conference to July 31st, 2025 at 9 a.m.
31st, Your Honor. Okay, at 9 a.m. Thank you so
Yes.
much. That works for us.
Thank you. Bond
Thank you, Your Honor. Have a
continued.
great day.
Thank you. You too. Court does call the case. People versus in beat me is it Agbu Zulu?
Alexander, on behalf of people, Your Honor.
Stephanie Canna on behalf of Bititmi Guzulu.
Oguzulu Alexander.
Your Honor, the E is silent in his name.
Okay.
Yeah, let you know. Oh, Your Honor, we are adjourning this case
You know what?
for mitigation purposes. I do
Let me
understand.
deal with her one day a week.
You got lucky. this
One
week.
day.
You got-
One day. I think you were here 2 days.
You got lucky.
So I'm over it.
There you go.
And Your Honor, if we could address bond. Good.
And Your Honor, we understand he also has a bond violation.
Yep. Go ahead, Ms. Senda.
Your Honor, this would be a further violation of his bond as he third parties from the jail, and I will just paraphrase one of these conversations. As long as she doesn't show up, then they'll just knock the case out. All right, do you want me to tell her not to show up? Well, she already said she's not. All right, I might shoot a text and say, hey, don't show up to that court thing. He says, no, I think you should drive there. Ain't nothing wrong with you going there. He says, all right, talk to her in person. So I have concerns he's calling third parties, having them talk to the victim, go to her residence, see her in person to tell her not to come to court. And I would be asking that his phone privileges also be revoked.
Any response?
Your Honor, I have talked to my client about that. I was informed that this did happen. I actually don't have a copy of those. However, I trust that the prosecutor's office will be sending me those. Your Honor, my client is understanding that he cannot do that. He will not be doing that. And he is asking that his phone privileges remain in place. As to the prior violation, Your Honor, my client works for the property management. That's how they have the apartment that they live in. So on that date in question for that particular violation, he did not go to the resident. He was not in the residence. He went to the shed, we'll call it a shed, located on the property. He retrieved his tools and then he left. So
He could have done that with a civil standby.
he didn't go into the apartment, Your Honor.
Yeah, but I'm
Complex.
real concerned right
I
now
understand.
because the phone calls clearly indicate an attempt to get in contact with this victim, and then he's in the vicinity violating his condition. But you can go on if you wish, Ms. Camp.
No, Your Honor, I believe the court has all the information they need.
His bond in this matter is revoked based upon the bond condition, and his phone privileges are also revoked.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Your Honor, what was the new date?
Was that it? I did not. You're looking for an adjournment. Probable cause conference, July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Court does call the case People versus Ryan Piper.
And Alex Warren Green on behalf of Mr. Piper. Mr. Piper, can you state your name for the court, please?
Ryan Pieper.
Your Honor, today's date and time for a probable cause conference in light of Mr. Pieper's restoration to competency, I would be asking for a preliminary examination in this case.
Discovery is complete then.
Believe so, Your Honor.
And would the people have their witnesses available the 22nd?
Yes.
Preliminary examination in person, July 22nd, 2025. That's Barr. 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus London Daughtery.
Andrew Childers, on behalf of people.
Hannah Mackey on behalf of Mr. Daughtery, who is approaching to my right. Name for the record.
London Daughter.
Your Honor, we respectfully request to adjourn this matter for further investigation.
For what?
to look into the case a little bit more. Into the police reports and everything.
It's like a movie, it gets better. Probable cause conference, July 31st, 2025, 9 a.m. Bond continued.
Thank you.
Right.
Cinda, I apologize for what I said. Mr. Allen is making me apologize to you also.
Can I have one?
So I'm sorry. Wow, the whole table? I like Getty. Court calls the case, People versus Farage Scott.
And Assistant Public Defender Chinazi Carrie Akinwale, Your Honor, on behalf of Mr. Faraj Scott.
I didn't know if you were gonna do anything today other than that order that was taking forever. All right.
That's two things. State your name for the record, Mr. Scott.
Verizon Scott.
I have-
Thank you. You're welcome. All right, what are we doing on this?
Judge, I have a green sheet. We are currently working on mitigation for Mr. Scott, so we're asking for an adjournment to continue that.
All right, so you're working on the mitigation.
Yes, Your Honor.
What do you have as bonds? I can look at it, that's all right. I'm just trying to think, how much time are you gonna need to?
I think the 31st should be fine.
Should be okay.
Yes, Judge.
Probable cause conference then, I'm good, Ann. To July 31st, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Calls the case, People versus Devon Haywood.
Anna Mackey on behalf of Mr. Haywood, who is approaching to my right. Please state your name for the record.
Good morning, Your Honor, Devon Haywood.
Thank you.
Your Honor, I believe you reached a resolution in this matter.
You have. And it's here.
Perfect.
That's right, this is the one that, hang on a second, this one, sure, this is the one that I looked at. All right. We have a plea form in this case that the defendant would be pleading to the charge of use of a controlled substance. I don't have, how come these forms aren't that hard to fill out?
Pardon?
How come I don't have the maximum penalty on here of what he's pleading to? Who did this? Mr. Childers? Mr. Childers, type. Childers, you know what? No, you know what? It's typed. Did you type it?
No, I did.
You didn't. Who did?
It was a group effort, but I'll take.
I appreciate Ms. Mackey because she provided me with the basic love. This is well, I think we're both at fault here.
It just felt.
Provided me with a mostly typed out plea form. All I did was look at it, sign it, and send it back to her.
Because if it was up to me.
I fill these out myself.
Correct.
I appreciated Ms. Mackey doing my work for me. I'm not gonna, stop there.
Well, she half did it.
Yeah, and so we both.
I wasn't going to put a max penalty for my client.
What?
It felt wrong to like do that part. So I was like,
that hurt. I just couldn't write that. I couldn't type that part. What is the maximum penalty on the one that, pardon?
1 year.
1 year, 2,000. It was a group effort. I like how they all sat there and tried to protect each other. All right. May I have him sworn?
Solemnly sworn to affirm the testimony you're about to give the truth, the whole truth. So help you God.
I do.
State your name.
Devon Haywood.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of a controlled substance. That's a misdemeanor. punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that, sir?
I do, Your Honor.
Do you understand what a no contest plea is?
Yes, I do, Your Honor.
All right, two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I understand.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I do.
All right. Basis for the no contest plea?
Civil liability, Your Honor.
All right. And sir, to this charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct, sir?
Yes, sir, Your Honor.
Do you have any question regarding any of those rights?
No, sir, Your Honor.
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am. I'm on probation for. Explain the case.
Well, were you on probation at the time of this offense?
No, Your Honor.
All right.
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. The court has been provided Washington County Sheriff's Office report, and I've also reviewed that report for their case number 24-42704. Any objection to the court having reviewed that report?
Okay.
None from us, Your Honor.
All right. Sir, you also understand that if between the time I accept your plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the court rule, two things would occur. You would not be entitled to set aside your plea, and the court would not be bound by any sentence agreement and or evaluation of your case. You understand that, sir?
I do.
All right. Based upon the review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt. Before I accept his plea, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Not yet, people.
None, Your Honor.
All right. Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
August 14th, 2025 at 10 a.m. in Judge Washington.
August 14, 2025. What time?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, sir. Court calls the case People versus Derek Stevenson.
Jacob, can I be asked to be Your Honor? All right, floor over, people.
Michael, he just.
How you doing, sir?
My apologies, Your Honor.
Michael Gaddy, Assistant Public Defender for Mr. Stevenson.
Your name, sir?
Derek Stevenson, how you doing, Your Honor?
I'm doing well. Thank you, sir.
Yes.
Your Honor, we have submitted a green sheet in this matter. We'd ask for a brief adjournment so that we can obtain video discovery.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you.
Court calls case People versus Michael Frazier.
Assistant Public Defender Jay Bellinger on behalf of Mr. Frazier, who appears via Zoom. Mr. Frazier, can you please state your name for the record?
My name is Michael Valentino Frazier.
Thank you.
Your Honor, I am just asking for a 2-week adjournment on this matter. An offer was just made to me. I'd like time to discuss that with Mr. Frazier to see what he'd like to do.
Probable cause conference, July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Court does call the cases of the people versus Bryce Valero.
Roba Handon on behalf of Bryce Valero. Can you please state your name for the record?
Bryce Valerio, Your Honor.
Your Honor, we're requesting a two-week adjournment on this matter for negotiation purposes.
Probable cause conference will be adjourned. July 22nd, 2025, 9 a.m. Bond in each of these matters will continue.
Sorry, am I done, Mr. Simpson?
Oh, yes, sir. You're good, Mr. Frazier.
Okay.
Thank you
appreciate
for
it.
waiting and asking.
Yes, sir. Thank you.
Your Honor.
Thank you.
Thank you.
Court does call the case people versus Serrano Johnson.
Public Defender Chelsea Vergils with and on behalf of Cyrano Johnson. Mr. Johnson, please state your name.
Cyrano Johnson.
I mispronounce your name every time, sir.
It's okay.
I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He presumably has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Are you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beer.
Hold it. You know what, sir? Don't play fast and loose.
I got you.
Story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour.
No, I didn't have
in
that.
order to reach that level.
Sure.
And could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
In regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders. I
Well,
understand.
I don't think he's going to have a choice on that, quite frankly, Mr.
You're-
Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I do.
The way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded. Court does call the case, People versus Fred Willis.
Your Honor, to go to the people. And Alex Warren Green on behalf of Mr. Willis. Mr. Willis, can you state your name for the court, please?
Fred Willis.
Thank you. Your Honor, today's the date and time for probable cause conference in both of these matters. I have completed 2 adjournment request forms. We are requesting to adjourn both cases. We need to complete discovery in the discharge at a building case.
Got it.
Thank you.
July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued. Now, Mr. Gallatin's case, I will file that. Will be stated the 17th.
Yes, sir.
Court does call the case of the People versus Stephen Johnston.
Laura Yagi, Assistant Public Defender, hopefully with and on behalf of Mr. Johnson, who indicated to me that he was on Zoom. Okay, Mr. Johnson, can you unmute and state your name for the court? Thank you. Your Honor, I am asking for an adjournment in this matter to continue conversations regarding the next step in the case.
Probable cause conference will be adjourned to July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, sir. Court calls the case People versus Alvin Jones. Ms. Weidling, if you could let Mr. Gilles know. All right.
Andrew Children.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Jones, who should be appearing via Zoom. I did see him earlier.
I see him, but, well, I see the A.
Mr. Jones, you can please turn on your camera and microphone and state your name for the court.
Bukovich.
As my client is, I did see him on Zoom and it's been indicated by the court he is on Zoom. I would ask for a brief moment to pass this to see if I can help him get his technology working, because I did see his camera on earlier.
Okay.
Alvin Jones.
How are you gonna do that? Oh, is she calling? Cannon gets involved, bad things happen.
I will call him myself.
Okay, good enough. Just saying. Court calls the case People versus Anushka King.
Great introduction, Your Honor. Cannon on behalf of Ms. Anushka King, who is appearing to my right. And Your Honor, this is a plea agreement.
Yes, it is. Your name, ma'am?
Anushka King, Your Honor. Good morning.
The plea agreement that I have indicates that the defendant will be pleading guilty to the charge of operating with a high BAC second offense. That is a misdemeanor punishable by up to 1 year incarceration. There's further an agreement, and that's count 4. Then counts 1, 2, and 3 would be dismissed. The defendant is also agreeing to complete screening at the 16th District.
36.
Yes, it's 30.
It's 36. They made a mistake
Is it-
on paper.
No, I didn't. It's 16.
It says 16.
36 would take the transfer.
Oh, okay, thank you. Okay.
Your Honor, she will complete one, yes.
Yes.
What?
She will be completing the one at the 16th District this Friday court.
So we're all in agreement to 16.
Yes, we are.
All right, 16th District Sobriety Court, including submission of all required documents, participation in all required interviews and assessment, contravention of acceptance or denial must be forwarded to the APA. That is the court's full understanding of the agreement. I am going to check box 5 on this form, which is the sentencing judge waiver. Did she read that over, counsel?
Correct, yes. Yes.
Okay. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Anushka King.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating with a high BAC second offense. That is a misdemeanor punishable by a $200 to $1,000 fine plus court costs, 5 days to 1 year in jail. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B district court. You understand that?
Yes.
All right. Now, understanding all of that, you still wish to plead guilty.
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights.
Understand?
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
I do.
March 3rd, 2024, at the location of I-94 near Wired Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
I did.
What did you have and how much?
A couple of shots. I don't remember in some coolers.
Pardon?
A couple of shots. I don't remember exactly how many. And I had 2 coolers.
Shots of what?
Tequila.
Were you stopped by the police or was there an accident?
I was stopped.
All right. Why'd they stop you?
I run around a semi truck. I get panicky around semi trucks. I sped up and I went around him to get ahead of him because it was construction in the area. And I was
Okay,
on my
so
way. Speed violation.
there was some type of erratic driving?
Speed violation. Yes,
Okay, you're not disputing the right of the police to stop you in this case?
I'm not.
All right. After they stopped you, were you ultimately arrested?
Yes, they took me to the hospital.
And there was a blood draw?
It was blood draw.
And
After
what was your
Your Honor, if I may,
results?
the prosecutor and I have agreed to stipulate to the findings of the Lansing Forensic Laboratory forensic report, laboratory number TX 24-3306, whereby it was found that,
I just need a number.
oh, sorry, Your Honor, 0.216 grams of alcohol per 100 milliliters of blood. Well, we were stipulating to the findings, Your Honor, my apologies.
No, it's okay. I was gonna let you go, but
Okay.
I ain't got all day. All right. Ma'am, do you have any reason to dispute those results?
I don't.
All right. Had you previously been convicted of operating while impaired on or about April 5th, 2022 in the 23rd District Court, and or of operating while impaired on or about February 16, 2021 in the 43rd District Court?
Yeah.
Yes?
Yes.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
None, Your Honor.
All right. And ma'am, I do have to advise you that if I do accept your plea and you commit misconduct as defined by the court rules, any evaluation of your case, the court would not be bound by that, any evaluation, and you would also not be entitled to set aside your plea. You understand that?
I do.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
You have, Your Honor.
Court will accept the defendant's plea to count 4. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A or 14B probation. Sentencing in this matter will be
August 14, 2025 at 10 a.m.
August 14, 2025, 10 a.m. before Judge Washington. Bond with its conditions will continue. Thank you.
Thank you.
Thank you, Your Honor.
Do you want me to fill out a sheet for that?
That was nice of you. You usually don't share. Court calls the case, People versus Romeo Smith.
Rachel McDuffie for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Smith, who appears via Zoom from the jail, Your Honor.
Yes.
It looks like he's muted.
He is.
Mr. Smith, can you please state your name for the record?
Muhammad Martez Smith.
All right, thank you.
Your Honor, we are here for a competency review hearing today, and I suppose I can let this serve as information to the court and everyone around me. I reached out to a couple of contacts at the CFP,
And they responded back to me with the following, and that due to limited bed resources and increased demand throughout our hospital system, there are extended delays in our admission process. As a result, we anticipate that Mr. Smith will be admitted for competency restoration treatment in approximately 1 to 2 more months. I contacted them about several other clients and they gave me the same exact response. So I wanted to let the court know that. It's very unfortunate, certainly, but that's what they gave me.
Okay. That's my last date in August is what?
August 19th.
I'm not here the 28th. Thank you. What I will do is I will adjourn the competency review hearing to August 28th, 2025, 9 a.m. If we get something before then, certainly we can move that date up, but that's going to be our best shot at this point.
Thank you, Your Honor.
Thank you. Case People versus Darien Rhodes.
Twice a month for alcohol. She's expected to have a newborn child coming up. She's doing a great job with her work, and she's making a lot of progress, Your Honor. She does acknowledge the fact that she's done wrong. She's gone through a lot of challenges, but I think it's best. This happened for a reason because of what she's going to become going forward. So those are really the only requests that we have. Other than that, she understands all the other conditions. She's written them down, and she's going to take care of it. And she's going to be successful on probation.
Thank you. All right, Ms. Jones, is there anything you'd like to say today?
I do want to say everything that he said, I do agree with, and thank you for saying that because it is true, and I have been working really hard to make sure that I am compliant with, the requests that are being asked of me. And yeah, that's it.
Well, I did have an opportunity to go over the PSI report as well as the assessment, and Ms. Jones, it looks like you are taking this seriously. You've been working really hard, and I do appreciate that. We've had a number of discussions since you tested positive back in March, because there were a couple issues that you had at that time. You've been doing better since then. And I think you're taking it seriously now. I did give you an opportunity after then to drop the testing down to 2 times per month. I am going to follow the recommendation with a few modifications. I hope, and I hope that you understand how serious the situation was. I think we do need to correct the report. There was no crash involved in this case, correct?
Correct.
Correct, Your Honor. I didn't catch that one.
All right, so we're going to strike that. We're going to remove the crash involved. It's on the right-hand side at the very top of the report. So I'm going to strike that part. She was just stopped. So given that, but even with that, you need to understand that drinking and driving kills. That's why you're are going to do if you haven't done the MAVEX impact panel, so you can understand the seriousness of your actions. I'm gonna follow a recommendation. I hope you continue to take it serious and you never do that again in your life. Is sentence of the court that you serve 93 days in the Washington County Jail, credit for 2 served. The balance 91 days are suspended. So you won't have to do any jail time as long as you do what you're ordered to do. You're to complete 5 days for a total of 40 hours of community service. You are on probation for a total of 18 months. Fines and court costs in this particular case for a total of $725. $30 per month probation oversight fee. You're to report to the probation department on a monthly basis during the second week of each month. You're to complete an outpatient assessment within 14 days of this sentence and sign a release of information so that the probation department can see what it has been recommended. You're to complete the MAD victim impact panel within 45 days of the sentence. There is no use or possession of firearm components, ammunition, dangerous weapons, alcohol, marijuana, illegal drugs, drug paraphernalia, and he'll be in the presence of anyone using those. You're to continue your drug and alcohol testing 2 times per month. And any other times is ordered by the court, probation, police agency. You are to attend 12-step meetings 2 times per week. And I'm gonna have you do that for the first, I'm gonna have you do that till you come back and see me at least, and we can talk about it after then, okay? And then I'll see you in 90 days, and that'll be on October 9th, 2025 at 10 o'clock a.m. She also has the 24S 4444387, which she's here for sentencing today on as well. And it's open intox. Is there anything you want to say about that? There was no report on that. I'm not gonna put her on probation on it. I'm just gonna give her fines and costs.
Nothing for the defense, Your Honor. Thank you.
Anything from the people?
Nothing from the people.
$125 fines and costs on that one. Okay, ma'am?
Okay, and I do just have a question, as far as like the testing. So, I still have like the Link device. So if I'm going to be doing like, the probation recommendations and then also testing, and seeing my PO, weekly, well, monthly, is it like, can I take the Link device out just because like, financially, like it's already all a lot. And so, instead of paying for my tests, my probation, $30 a week and the Link still, like it's just, if that can be, something.
Mr. Mansour, you represented that she was testing twice a month, and that, I don't think that's correct. She's on Link. So that's why
I'm testing twice a month and I'm doing the Link twice a day.
you're testing for drugs twice a month, right?
Yeah, but I still blow, like, so I do the alcohol and drugs when I go there.
Oh, got it.
It is testing twice a month, but it was for drugs and alcohol with the Link.
Oh, I see. What I'm gonna do is just leave her on Link. So either she's gonna be on Link or she needs to test 4 times per month, like the agent said. That's the step down once you're on Link.
Okay.
Yeah, all right, Your Honor, we appreciate that. Maybe when we come back for the review in October, we can address the Link issue.
All right, which one does she want to do 4 times a month and take the
No.
Link?
No, I would rather do the Link, because the testing, it requires me to like leave work early and it's random, so it's kind of a conflict with my job. So,
You can stay on, then you can stay on the sober link, okay?
okay, thank you.
You're welcome. And I'm gonna remove the other testing. So it's just the sober link. Okay?
Thanks, Your Honor. Thank you.
Thank you.
All right, contact the probation department, Tuesday after 9 o'clock, okay?
Okay, thank you.
Have their phone number?
Yes,
All right, thank you. You're all set.
thanks. Have a great day.
You too. Bye-bye. The court will call the case of the state of Michigan versus Elise Hardesty, case number 24S 00213.
Tiffany Woods for the people.
Matthew Mansour on behalf of Miss Hardesty. Elise, can you unmute and state your name?
Hi, Elise Hardesty. Thank you. We're here for a review today.
We are, Your Honor. There was a report that was sent out, and I went over the report with Miss Hardesty. She understands exactly what she needs to do, and we are asking the court to follow the recommendation.
What's anything from you?
Judge, I've also had an opportunity to review the report, and it looks like she did not meet the requirements for anger management program. So the probation agent is recommending a 1-day ABR program. So we asked the court's discretion as to how they want to handle that request. Thank you.
Thank you. Anything from you, Ms. Hardesty?
I'm not sure about that. I went to the anger management and he told me I passed everything and I wouldn't need to go to any classes. I didn't think I had to proceed or do anything further with anger management.
Okay. Well, what you went to was an assessment for a particular program, and they said you didn't need to do any classes through them. In terms of what you need to do what the probation department recommends and I order. So you're going to go to the ABR class, which is a 1-day class, okay? And then we'll do a review here in 90 days, okay? All right, and that will be on October 9th, 2025 at 10 o'clock a.m. We'll see you then, okay?
Honor.
Thank you. The court will call the case of the state of Michigan versus George Turner, 22 FB 1123.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. George Turner. George, can you state your name, please?
George Turner.
Thank you. Good morning, Mr. Turner.
Good morning.
It looks like you have turned things around here and you're doing so much better. You have been for a while now. Congratulations to you, Mr. Turner.
Thank you.
How do you feel?
I feel good. Feel good, real good.
All right. There is the issue of you still not completed your community service?
Yeah, you said 3 days, right? And I turned in 27 hours
You
to Ms.
did.
Johnson.
Here it is. I have it from Miss Michelle Lamis. All
Yes.
right. Thank you. Good. All right. So I think what she's recommending, anything from anybody on this one?
Nothing from the people, Judge.
Nothing from the defense, Your Honor. Good job, Mr. Turner.
Thank you.
All right, Mr. Turner, what she's recommending is that if you do, if in the next 90 days you continue to remain negative, she's going to recommend that you have early discharge on your probation.
Oh, okay.
Let's see here.
Your Honor, if I may,
Yeah.
when I looked in the report, it was a bit conflicting, but I think it was an old statement. If you look at the report, it says something about what, what was it? Community service and reporting, I believe. But I asked him about that in a breakout room earlier today, and he has been reporting and he has completed his community service. I mean, and I believe he has like proof that he's reported. When you report online, it shows that you've reported, I believe. So I'm thinking it was an older statement. And I know Miss Johnson's not here right now to really ask her, but that was the only thing that kind of confused me about it. But the recommendation,
I think you're right about that. I think that, I think she made some corrections that just didn't get into the report. But his probation, I was looking at his probation to try to understand it. But I don't understand the end date. Let me see here. Oh, because he's on 5 years of probation, that's why. Okay. So I see she'd be willing to recommend early discharge if in 90 days he's still doing well. I was looking at the term of the probation to understand why he wasn't eligible yet. That's what I was looking up, not the concern with the reporting, in case you were wondering.
well, I forgot about it, and I was like, oh yeah, I just wanted to bring it to the court's attention. But
All right, thank you. All right, I'm going to see you back here in 90 days. That's going to be October 9th, 2025. Please keep doing well, sir. I'd like to see you discharged earlier so you can be done with this. Okay.
I sure will.
All right. And Miss Woods, if you're gonna have any objection to it, I'm not saying you are, but if there were, you need to have something filed before then. So please note that.
Thank you, Judge.
So October 9th, 2025 at 10 o'clock a.m.
Now good.
Please continue to report and do what you're supposed to be doing.
I sure will.
See you on October the 9th. Have a good night. Day.
Yes, you too.
Thank you.
Yep.
What we'll call the matter of the state of Michigan versus Darius Castello, case number 18-00203.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Darius Costello. Darius, can you unmute and state your name?
Darius Costello. I'm on Zoom, sir. Hello,
Thank you. Hello, sir.
can you hear me? Oh, hello.
Yes, I can. All right, Mr. Castello, you're here for payment today. The report I have is from July 7th, and it looks like you hadn't made a payment since April of 2025. Have any payments been made since July, Mr. Mansour? July 7th?
Not according to JIS, Your Honor. I tried to give Mr. Costello a call. I couldn't get a hold of him, but it looks like he's working right now, so he can make a payment coming up. Hopefully, if he gets paid this Friday or next Friday. But it
It'll
was
be next
Friday.
Next Friday. Yeah.
Mr. Castello, when you were here, last time, I think you told me you were gonna pay.
No, I don't think I told you that. I made a payment the day before my court date. And then I said I was gonna try to continue with the payments. So yeah, I did tell you.
And you didn't do that. So this is what I'm gonna do, Mr. Castello. You are not paying according to your schedule. You need to get back on schedule. I'm gonna set it for a contempt hearing. Contempt means that you need to show the court as to why you shouldn't be held in contempt of court and have to do some jail time for failing to pay on your fines and costs. Schedule it for a contempt hearing on September 11th, 2025 at 10. If you haven't made any payments on your fines and costs, then like I said, you could be found in contempt and have to do jail time. Okay?
All right.
All right, thank you. Are you talking to me? Oh, let me see. I don't think so. No. All right, the court will call the matters of, Ms. Cara Moody. Case numbers 23S 00085, 18T 10949, 19W 00183, and 22W 0042360.
Tiffany Woods for the people.
And Matthew Mansour on behalf of Miss Moody. Miss Moody, can you unmute, put your camera on, and state your name for the judge?
Kyra Moody. Thank you. You need to turn, TV on your back, Moody.
Go in there with your sisters. Go in there with your sisters, don't even talk. What? Go in there with your sisters and try to get off course. And say, in there with your sisters. In there with your sisters.
Right.
Come on, stop all that. I said, in
Miss
there with
Moody, Miss Moody, can you
Yeah.
just mute real quick?
Yeah.
In case number 23S 00085, we're here for a violation of probation sentencing. In the other cases, we're here for either show causes or reviewer payments by Ms. Moody. So let's start with the sentencing, please.
Thanks, Your Honor. Me and Miss Moody went over the report. We accept its recommendation. I know we were here for the violation a few months ago or whatnot, and we've handled it. We've moved past it, and right now we're focusing on getting to the finish line. The recommendation is to complete a mental health assessment within 7 days. I advised Miss Moody to reach out to probation to see how she can get set up with that, and if they still want her to do that. Because I believe me and Miss Moody were talking about something about she's seeking counseling at the moment, I believe, Your Honor. So she just wants to talk to the agent before actually doing the assessment to see exactly why a mental health assessment is being recommended now at this stage in probation. But like we talked about, we're willing to do it if the court deems it necessary, and will do it. She understands to continue to do the AA meetings. She will do that once a week, and she will provide proof, and she's going to continue testing. Honestly, the biggest problem that we had in the past was her testing. She was missing tests and whatnot, and that's why we had the hearing. But we've obviously addressed that. We moved past it. We've admitted to it, and we're just focusing on getting to that finish line. This has been a journey.
Ms. Woods?
Judge, I would leave this up to the court's discretion. Thank you.
Ms. Moody, what would you like to say today, ma'am?
I did call Mr. Papenhagen yesterday afternoon about the mental health assessment. And he said that was basically for me to continue the outpatient treatment that I'm currently doing. But he said he didn't have the information for that. But I thought I previously, like 2 months ago, sent him that. But I did send him all the information as far as my counselor and everything.
Good morning, Mr. Papenhagen.
Good morning, Your Honor. So with that, I knew there was some mental health in the background.
I wanted to make sure that she was seeking treatment because I've never been able to get a hold of her current therapist. And the last time I was able to, basically, I was told she wasn't compliant with the program. That was months ago. I tried to contact her yesterday, was unable to even get someone to pick up the phone. The same goes with this morning.
Thank you. I appreciate it. So that's the answer to why he was seeking that. We've been dealing with the mental health stuff since we started this process. If she was not compliant, it creates a huge issue. This is Ms. Moody and I go way back at this point. We've been dealing with this case for an extremely long time. I think this is your third probation agent, Ms. Moody, is that correct?
No, this is my second.
So you had Ms. Straub before?
Yes.
You never had Mr. Heaton?
No, ma'am.
Okay.
But I have been doing my counseling. I do that every week.
Mm.
And I also see a psychiatrist.
I think those are the proofs that we need. We can get those proofs, then you don't have to do another mental health assessment. We don't get those proofs, and then you do. Okay?
Okay, what do I need to get? I mean, what do I need to do to get the proofs?
I think you should talk to your attorney about that. He can maybe help with that.
Yeah, Miss Moody, give me a call after court. We'll handle it.
Okay.
And then the recommendation is that you attend AA meetings one time per week and provide proof. I'm going back to when you were originally sentenced back in June of 24. Have you ever attended those AA meetings you were supposed to be attending?
You said back in June?
I'm saying since that time, have you ever attended any of the AA meetings, ma'am?
Yes, ma'am, I have.
Your Honor,
Yes.
I put that in there because I hadn't received any in a while. I just received a bunch of them dating back to May yesterday
Okay.
after the report was filed.
All right. Are you still requesting that she continue to attend those, or what is your position, please?
I think she should still be attending those meetings, Your Honor.
Okay, thank you. All right, ma'am. You to complete a mental health assessment within 7 days if we do not have compliance with the program otherwise. So if you provide the testing documentation or, I'm sorry, the counseling documentation to us, then we wouldn't have to have another assessment. You need to continue to attend the AA meetings one time per week and continue with your testing. And we'll do a review of this case in 45 days. Miss Moody, I know you're sick of seeing me. Quite honestly, it's mutual. I hope we can get this case done. And you don't have to keep coming back here. I think I've seen you probably more than I've seen any other defendant. So I'm hopeful that you can test consistently, do your AA meetings consistently, get that assessment information into us. And seriously, I know you want it because you've asked. I would consider discharging you, but you've got to do the right thing consistently for at least the next 45 to 60 days. Okay?
Yes, ma'am.
So I'll see you here on August 28th. 2025 at 10. If you are consistent, I will consider discharging you. Okay?
Yes, ma'am.
All right.
Thank you.
You're welcome.
And Your Honor, that other case, the review payment is set for that day as well, Your Honor.
Yes, is she making any payments?
She's going to be.
Okay. It's a lot that she has to come to show us because she has some issues. So the payments is not gonna stop her from getting discharged. I need her to do the other stuff. That's what I need. Okay?
We completely understand. We know, and we're gonna get it. We're gonna make sure it happens. We're almost there. We're making progress.
Yes, we are. We are finally making some progress. Thank you, Ms. Moody. I'm gonna acknowledge that I see progress. Okay?
Thank you, Your Honor.
You're welcome.
Bye.
Bye-bye. We'll call the case of the state of Michigan versus Tequila Evans Guyton, case number 25 FB 1067.
Tiffany votes for the people.
Matthew Mansour on behalf of Miss Evans Guyton. Miss Evans Guyton, can you please unmute and say your name?
You're still muted, Ms. Evans Guyton.
Okay, I figured it out. My name is Tequila Evans Guyton.
Thank you. We're supposed to be here for sentencing today, but apparently she
Yes.
failed to contact the probation department.
Yes, Your Honor. This is more common than it should be, and I don't know. It's I don't know whose fault it really is. It's kind of confusing because when somebody pleads at PCC, there's a lot of times where there's a disconnect with reaching out to probation, and that's really what it is. She was confused about the whole process. You know, when you're in PCCs, then you're being told to call a different court and whatnot. So it was not intentional. It was just a confusion, and I'll make sure she gets the right number and set up an appointment and an interview with probation going forward. We're just asking just one opportunity to reschedule.
Hearing no objection, I'm going to give you that one opportunity, ma'am. If you fail to schedule your appointment next time, then we'll have to do this from you being in custody, okay? So you need to contact the probation department. Do you have their phone number?
Yes, I do now.
Okay. Is there a Tuesday? Let's do, what does August 12th look like for sentencing? Well, not sentencings, but that's terrible. Okay,
We currently have 5 set.
okay, I'll do that. I'll schedule this one for August 12th, 2025 at 10 o'clock a.m., okay?
Okay.
That's a Tuesday. You're welcome. Your bond is continued, ma'am. We will see you then.
Okay, you guys have a good one.
Are re-referred, I'm gonna hold the re-referral fee under abeyance, hold it in abeyance, okay? So show me that you're gonna get it done and there will be no re-referral fee.
Okay.
All right. Thank you. Take care, ma'am.
Thank you.
We'll call the case of the state of Michigan versus Stefania Ramirez, case number 24S 00011.
Tiffany votes for the people.
Assistant Public Defender Davy Lebo for Ms. Ramirez. Ms. Ramirez, can you state your name, ma'am?
Estefania Ramirez.
Thank you.
And Your Honor,
Go ahead.
And Your Honor, Ms. Ramirez did provide me with documentation of proof for community service earlier this morning, and I did provide that to the court and Mr. Pappenhagen.
Mr. Pappenhagen, sir, are you still present? Do you acknowledge receipt of that?
Good afternoon, Your Honor. Yes, I do. I received all 48 hours of community service that was required, and I see that she's paid off, I believe, all her fines and costs.
Did she test within 24 hours? Let me see. She tested negative. Okay. Anything from the people on this?
Nothing from the people, Judge.
All right. Anything you want to say, Ms. Ramirez?
I just wanted to say that like I'm grateful for the opportunity to be able to complete the items that I had missing. I do want to recognize that it was a really hectic time for me finishing my undergrad. So yeah, I just like appreciate the extra time. Definitely with school off my plate, it was a lot easier to get everything in. And yeah, I'm appreciative to have the opportunity and move forward.
Thank you. Well, it looks like you got it all done. Your commitment to get it done so you could be done with this is noted. Okay. And congratulations for you completing everything. And you are all done and this case is closed. Okay.
Sounds good, thank you.
You're
I did have one question.
Yes.
Would I be able to get my license reinstated?
I actually don't control that. That all goes through the Secretary of State. And if there's any clearance fee that you need to pay here to get it reinstated, I will approve that. Okay. But I don't know if there's anything that you need to do here for that. But in the event that it is, you're approved to pay any clearance fees. Okay.
Okay, yeah, I
Ms.
think
Ramirez,
that's
I
the
can give you
only
a
thing
call
I
after court
needed.
and I'll talk to you about that.
Okay, sounds good.
You're all set. The Secretary of State is the one who controls it. So, okay.
Okay, thank
You're
you.
all set. Thank you. Take care of yourself.
You too. Bye-bye.
The court will call the case of the state of Michigan versus Angela Zagerman, case number 25S00121.
Tiffany Woods for the people.
Assistant Public Defender Davi Liba on behalf of Ms. Zagerman. Ms. Zagerman, can you state your name, sir, ma'am?
Angela and Zagerman.
Thank you.
You're
We're here-
welcome.
We're here for a pretrial today.
Yes, we're going to be requesting an adjournment. I did discuss some potential options we may have with Ms. Zagerman. She has indicated to me she's going to be providing me some further information, so I'm requesting just one final adjournment to get that information together.
Hearing no objection, the adjournment will be granted as July 24th, enough time.
That should be fine, Your Honor.
July 24th, 2025 at 9:00 a.m. Bond is continued. We'll see you then, Ms. Zagerman, okay?
Thank you, Your Honor.
You're welcome.
Thank you.
Bye-bye.
Bye-bye. The court will call the case of the state of Michigan versus Brianna Likes, case number 25S00120.
Tiffany Woods for the people.
Assistant Public Defender Davi Liba for Ms. Likes. Ms. Likes, could you state your name, ma'am?
Brianna Likes.
And turn on your video, please.
My camera is not working.
It was earlier. I saw you.
Yes, it was, and I just tried to turn it on, and it is not wanting to go on. I don't understand why.
Did Ms. Likes complete the impulse control class like I asked her to?
Unfortunately, Ms. Likes indicated that she did not complete that. She is asking the court to give her one final opportunity to complete that. I think she understands that she's going to do some jail time if she doesn't get that class done.
I ordered 10 days in jail or she could get that class done.
Ms. Likes, perhaps you would like to give the court an explanation of why you didn't get the class done?
Because I don't have the money to pay for it. Like, I don't have the money to pay for it. I have other court cases going on as well regarding my my child with divorce and everything, and all of my money is gone. I have no money to pay for this class, so therefore I'm not able to take the class.
Anything from the people on the contempt piece of the court date today?
Nothing, Judge.
All right, so she basically is telling me she doesn't have the money to take the class, so she can just do the 10 days in jail.
Your Honor, would the court consider a financial hardship statement from Ms. Likes?
Absolutely not.
Thank you.
Oh yeah, she just said absolutely not for that.
What were your plans with respect to the pretrial?
Your Honor, we were going to be setting for final settlement conference.
Well, this is where I am with it. She apparently is not going to complete her anything to purge her contempt because she's claiming she doesn't have the finances to do that. So she can do her 10 days in the Washington County Jail. I'm going to this is what I'm going to do. I'm going to give you your final settlement conference date of August 29th, 2025 at 9:30 a.m. and jury selection date of September 5th, 2025 at 8:30 a.m. That's in person, obviously. Defendant is to turn herself in to the Washington County Jail. By July 25th, 2025 at 8 a.m. If not, bench warrant will issue and all dates will be canceled.
I live in a whole nother state. Like, I don't live in Michigan.
Ma'am, that's not my issue. You can figure that out.
I'm not going all the way to Michigan just to turn myself in over something that I don't have the money to pay for.
All right. You're not turning yourself in over something you don't have the money to pay for. You're turning yourself in for your behavior when you were in court last time. So you can choose to not do if you want to. That's on you. Bench warrant will issue after that time. I'm done with this case. We'll call the case of the state of Michigan versus Deja Burbank, 21S00194, 24S447861.
Tiffany Woods for the people.
Assistant Public Defender Davi Lee before Ms. Burbank. Ms. Burbank, could you say your name, ma'am?
Ms. Deja Burbank, please unmute your device and state your name.
Okay, I'm getting it. Here I come. Okay, Deja Burbank.
Thank you. All right, we're here for a show cause in one case and a pretrial in the 601 case.
Yes, Your Honor, the show cause is now on my docket. With regard to the pretrial, I did send an email to Ms. Woods regarding a potential resolution. I have not heard back, so I suppose we'll be asking for an adjournment on that.
Ms. Woods, any response?
I'm sorry, is this not for me?
Judge, I must have missed that email. I apologize to Davi about that. That I
worries.
didn't get back to him. If I'd be fine with a short adjournment so we can get back in touch and talk about this case.
Is July 24th Does that work with everyone's calendar, including yours, Ms. Burbank?
Yes.
And that's been fine for me, Your Honor.
July 24th, 2025 at 9 o'clock a.m.
Okay.
Bond is continued. We'll see you then, ma'am. And as far as you owe $120 in case number 21S00194.
Okay.
You gonna be able to pay that between now and then?
Okay.
Is that a yes?
Oh,
You're gonna
yes.
get-
Yes.
Okay. All right, so I'm writing down defendant to pay before court, okay?
Okay. Thank you.
All right, I'll see you back here on July 24th, 2025 at 9 o'clock a.m.
Thank you. I'll see you.
See you then.
Thank you.
The court will call the case of the state of Michigan versus Tariq Pruitt Pringle, case number 23 FB 1348.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Pruitt Pringle. Mr. Pruitt Pringle, can you state your name, please?
Pruitt Pringle.
Thank you. All right, so we got a lot going on in this particular case. Have you had a chance to review this report with your client?
Yeah, Your Honor, we have. Mr. Pruitt Pringle knows what the recommendation is. And Your Honor, I would just like to say something on his behalf, whatever.
All right. Well, the report indicates that he appears to have no desire to comply with the terms of his sentencing. He turned in his community service, but he has not reached out to the agent. He did not do his gun safety program or make any payments, still owing $780. He failed to report a new criminal charge of domestic violence that occurred on October 6th, but I guess that case got dismissed. Is that correct?
Apparently, yes.
We got this next with straight prejudice.
Ms. Woods, anything from the people?
Judge, I would ask the court to follow the recommendation from probation to have it revoked and have him serve the remaining term in custody. Thank you.
I think that was the report from the last time he was here on May 15th. No, wait, I saw that report just a moment ago, but the newest report, that was the report from actually March. The report from today recommends 5 days in the Washtenaw County Jail and having him complete the services that were ordered. So
I'm sorry, Judge, I did not see that new report, but I'm fine with that recommendation as well. The 5 days and then have him complete the terms of probation.
okay. All right, Mr.
Yep.
Sir, I'm not speaking to you yet, but thank you. Mr. Mansour, what would you like to say on behalf of your client? I think we still, has he even pled to the violation yet? What was the violation? Or was that withdrawn? One moment. All right, I have the March 5th report that indicates that he failed to complete the community service as ordered and failed to complete the gun safety class. So obviously he's provided proof of the community service, but that was not provided until after. Mr. Pringle, do you have a TV on in your background?
Yeah, I'm sorry.
Turn that off, please. All right, but that was not completed until March 15th. It actually says it was completed after this was done. So and it also says to report to probation for over 60 days. There was the over 60 days is a violation which his probation can be revoked. It also indicates he had a new criminal offense. Obviously that been dismissed. So it would be the first 3 violations. What does he want to do? He is entitled to have a hearing as to those violations. Would he like to have a hearing, waive the hearing, and admit to the violations?
I'm pretty sure he would be admitting to the violations. If we haven't done them, then we would have to admit to them. The violations are not reporting, right? And the community service is not a violation because it's been provided, or it was provided late, so it is a violation.
It's still a violation.
Darn. Okay, and then the third one.
I'm sorry. Yeah, not completing
The gun safety. Okay, so this is the thing with the gun safety class.
No, Mr. Mansour.
I know, man.
You can talk to your client?
Yeah, I guess.
All right, I'll pass it so you can do that. All right, we have failure to appear. So let's handle those while Mr. Mansour is talking to him. The court will call a case of the state of Michigan versus Michaela Johnson. Any payments? No. Defendant has failed to appear, failed to pay. Bench warrant to issue $3,400. In June, defendant is defaulted.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Pruitt Pringle. Mr. Pruitt Pringle, can you state your name again?
Oh, I didn't
So
call that.
Oh, I'm sorry, Your Honor. That's on me.
Miss Rebecca Rose is supposed to be here for contempt hearing today. She failed to appear on 3 separate occasions before the magistrate. And no payments have been made. Contempt is found. Bench warrant to issue in the amount of 1,900, 10%. All right, the court will recall the case of the state of Michigan versus Tarakam Pruitt Pringle, 23 FB 1348.
Tiffany Woods for the people.
Once again, Your Honor, Matthew Mansour on behalf of Mr. Pruitt Pringle. Mr. Pruitt Pringle, please state your name.
Tarakam Pruitt Pringle.
Thank you. All right, Mr. Pringle has had a chance to speak with you in the breakout room. Where are we with this, please?
All right, thank you for that opportunity. We will be admitting to the violations, and if you could please allow us to explain ourselves afterwards.
Absolutely. All right, Mr. Pringle, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. All right, Mr. Pringle, is it true that at the time of the filing of this report, you had not completed the gun safety class?
Yes, ma'am.
And you also had not completed the community service? You did subsequently turn that in, but at the time you had not?
No, I did complete it. I just didn't turn it in. That was on my behalf. I did complete, I just didn't turn it in.
Mr. Pringle, so it says right here on this report from the Salvation Army that the date of completion is March 15th.
Yes, ma'am.
That was after March 5th.
Oh, yes, ma'am. Then yeah, I was late.
Thank you. And it also indicates that you hadn't reported to probation for over 60 days. Is that true, sir?
Yes, ma'am.
All right, thank you. I find that there's a knowing and willing admission to the violation. Are you satisfied? Ms. Woods?
Yes, Judge.
Answer satisfied, Your Honor.
All right. Now, what are these explanations?
All right, Your Honor, let's do it one at a time here. I'm going to start with probably the hardest one, the gun safety program. Your Honor, Mr. Pruitt Pringle, and I don't understand why the gun safety program even does this. I guess it requires you have to shoot a gun to complete the program. I don't understand why, and I think that is true. I've heard that in the past. I'm not sure why you can't just sit in a class and learn about gun safety without shooting a gun, but who am I? He got into an accident, a pretty severe accident a few months ago. Mr. Pruitt Pringle, can you please show your hand? He has a surgery upcoming in I think 2 weeks from now on the 24th. His hand is he has no feeling in his hand and he cannot obviously, and that's his right hand. I'm pretty sure he's right-handed. He can't shoot a gun to complete the class. Your Honor, if we could please just give him the opportunity to heal so he can complete the class, or they won't give him the certificate on that. And Mr. Works spoke with him, gave him a stern talking to. He understands exactly what he needs to do. He's going to be providing proofs of his medical situation. He's going to be reporting to Agent Johnson. That is for sure. That is one of the easiest condition. That is the easiest condition on probation. Literally picking up a phone or checking in online. It's unacceptable that we even are here for that. But there's no turning back after this. He's going to be reporting. And the community service part, it was late, yes, but it was done. Better late than never. So, Your Honor, please, 5 days Washtenaw County Jail. I know it's not good, but at least he did it. And not timely, and we got to be more timely. We talked about this. I know you have a lot going on. You have probation, in other counties or other situations. You have a life of your own, but we got to be more organized. We got to even keep a file, write things down. That's what we got to do, and that's what we are going to do. Our 5 days Washtenaw County Jail. I get the recommendation because this is poor performance, but one last opportunity here. We'll provide the proofs. We'll be checking in, and let's get this going.
Ms. Woods?
Judge, I would leave this up to the court's discretion. Thank you.
Thank you. So here's my problem, and I'm going to listen to you, Mr. Pringle, but I want you to hear some words from me before you speak so you can put them in context. And one of the things you need to start doing is listening. So here's the thing. Mr. Pringle has been doing this since early 2023. He missed his first probation interview. He had to be re-referred. Then he failed to appear for sentencing. And then when he appeared, we still gave him an opportunity. We said, hey, here are your fines and costs, complete the gun safety class, do 10 hours of community service. No probation. No probation. He comes back in November. He's not compliant. I give him a payment plan. He's still not compliant. He hasn't done the gun safety class. He hasn't paid any monies. He hasn't done any community service. And I say to him, last chance before you go on probation. He comes back 2 more months later, March of 24. That's over a year and 3 months ago. Still hadn't done anything. So actually, nope, he didn't even show up. He just failed to appear. So bench warrant got issued. He stayed in bench warrant status from March of 24 until December of 24. Guess he got picked up some kind of way and got arraigned up. And that's when he got his 6 months of probation. 6 months. I said it's short time period, so he could be done in 3 if he finally got it done. Mr. Pruitt Pringle came back in December, still hadn't gotten it done. Came back in March. No, he was here in December. He came back in March. He still hadn't gotten it done. March 20th, he came back and appeared. That's when I said I was going to set it for a violation of probation and a review. In between that time is when the report came in from Community Corrects from Salvation Army that he had at least done the community service. But there was nothing about him doing any of the other two remaining very simple things to do. So then you came back here in May for a review and a VLP, and my hope was finally, because they wanted to revoke then, send him to jail for the entire time. He should take this seriously now. He knows he's looking at doing the entire amount of time in jail on this particular case, which is a total of to him serve another 89 days. And now we're talking about the fact that he broke his arm or whatever he did, which I'm sorry to hear that, a couple months ago. That gives no explanation for the last year to year and a half that he didn't get it done before then. So, in that context, Mr. Pringle, what do you want to say, sir?
I'm not going to even like lie or anything. Like back then, I was like kind of like in my kiddish ways. I wasn't really taking anything serious. I can admit to that. I wasn't taking nothing serious at the time until I got arrested in November. No, October. I'm taking that back. I'm sorry. I got arrested in October of last year in 24. That's when everything really kind of hit me, and I got bounced around from county to county to county. I ended up in York County, the last county, and to me and everything. That's when I kind of started taking it serious, as far as trying to get done with everything. And I'm sorry, it's kind of hard for me to explain a little bit. I am off medication, so I'm sorry. So I'm just kind of explain it. Basically, I just wasn't taking anything serious back then. But now I'm taking it serious. I wanted to show you that I was taking it serious by getting my community service done. Now, the reason I can't do my gun safety class is because I can't shoot. And when you take the gun safety class, you have to be able to shoot 50 to 100 rounds.
It's not 50 to 100 rounds, but I've taken the class. So
yeah, just to finish, but I have to shoot, and
it's
I
not
can't shoot.
50 to 100 rounds, sir. That's not true. And secondly, I already just said to you, you just had that happen in March. Oh, or you just
I
had
got hit off from
the last couple of months. When did it happen?
this happened March 19th. I got hit off from I got a lady hit me off my motorcycle. I didn't have no helmet or anything right now, so I'm just blessed to be just like this. Right, I had surgery. This is my third surgery I gotta have. My hand and my wrist was broken. I had a popped out. I had a dislocated bone. I got a rod, 2 pins, 4 anchors, and 2 screws in my hand. So where I can only just do this with my hand. Like I really don't have nothing. Like, I can't do anything right now, literally.
Mr. Pruitt, I'm not going to sentence you today because I want to see proof of what you're telling me. All right. So one is I want proof of when this accident happened. And then 2, I want proof of his surgeries.
I told him I can send that proof. That's not an issue. I have that literally in my phone and everything.
August 28th, 2025 at 10. Yes.
Johnson, there's a gun safety class that does not require shooting that's offered through onsite.
All right. There's a gun safety class that does not require shooting that is offered through onsite.
Through onsite?
Yep.
Okay. I'll look into that.
All right. So one is I need proof of the surgeries. 2, proof of the accident when that happened. There should be a police report. And then 3.
There wasn't a police report. I'm gonna be honest, there wasn't a police report. The reason it wasn't a police report because I had just got that bike and it wasn't, I'm gonna be honest, it wasn't registered.
Just stop talking.
No, I was gonna be honest. I'm not
You're gonna admit to a crime, so I'm gonna stop
I'm sorry.
you.
Okay.
Thanks, Rod.
All right. And he's gonna be referred to the on-site to take the gun safety class. It would be in his best interest to have that done before he comes back here on August 28th. Okay? I'll see you on August 28th at 10 o'clock, sir. If you don't have that class done, or if those proofs don't show what you're telling me to be true about your arm, you're gonna do some jail time. So you should probably get both of those into me. Okay?
I will. That's not a problem.
All right. Thank you. Bye-bye.
All right.
Good luck with your
Bye-bye.
arms. Bye.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?